Welcome to another episode of In My View. In this one, we would take a look at the Supreme Court's September 2018 judgment related to Aadhar. The court ruled on a whole batch of petitions which had been pending before it for quite some period of time. This is supposed to be the longest running case before the Supreme Court, went on for almost 6 years. You had 5 judges who delivered this judgment, and it runs into almost 3 lakh odd words. It's quite exhaustive in the way in which it goes about treating a whole gamut of issues related to Aadhar. The law which was passed, the court is ruling on the law which was passed by the by the Parliament of India in 2016 about the targeted delivery of subsidies, financial benefits, and so on and so forth. The whole question before the court was Aadhar legal, or was Aadhar in some form or the other unconstitutional? And the other big issue that the court was dealing with was it tenable for the Speaker of the Lok Sabha to rule that the Aadhar Act which was placed before the House was a money bill. So what you get at the end of the day, as far as this judgment which has been passed by the court towards the end of September is concerned, yes, by a unanimity they have said that Aadhar is constitutional, is legally tenable, and there's no problem as far as both the act, the bill, and the way in which it was passed and so on and so forth is concerned. And you get one dissenting judgment by a highly erudite and considered to be a very liberal judge in liberal circles, by Justice Chandrachud, which almost takes a diagonally opposite view of whatever the concurring judges and whatever the majority judges have said. So you get 3 judges, that's Justice Deepak Mishra, Justice Sikri, and Justice Khanwilkar, as part of a majority judgment, all 3 of them signing on the same judgment, saying that Aadhar is constitutional, there is no problem with it, and it should go on in public interest. Then you have Justice Ashok Bhushan delivering a concurring judgment, but grounding it slightly differently in terms of the way in which he has argued it, in terms of the way in which he has put issues forth, but nevertheless concurring with the majority judgment. And then you have Justice Chandrachud who says that, well, it's unconstitutional. The very way in which it was passed in Parliament is almost a fraud on the Constitution, and so on and so forth. So what you have now, as of now, is this whole problem as to how should one go about reconciling the fact that 5 judges hear the case in the last stages for almost 40 days at a stretch, sitting together as part of the same courtroom, and yet come up with so divergent views regarding the whole issue. For a matter which is as critical as Aadhar, this definitely calls in for a certain level of introspection on part of practically all the stakeholders who need to take a look at all of this and decide as to what needs to be done about it. The court has moderated its idea related to Aadhar, especially in light of what the court passed in August 2017 as part of what was known as a privacy judgment. So in August 2017, the court almost lays it down in no uncertain terms, no wavering, no ambiguity, everything absolutely clear, that yes, though not explicitly mentioned in the Constitution, privacy is a fundamental right that is enjoyed by the citizens of India. And in light of this, those who wanted Aadhar to be declared unconstitutional do feel that, well, if the court has said that privacy is a fundamental right, and the way in which Aadhar goes about collecting biometric data, it almost seems to be an infringement of that fundamental right. So, by looking at the judgment passed in August 2017, the court would in 2018 take a call and declare Aadhar to be unconstitutional. But the court almost does an U-turn and says that yes, Aadhar is constitutional and should continue, and there is no problem with it, notwithstanding all manner of issues related to privacy. Now, as far as privacy is concerned, and especially in this case data privacy is concerned, the problem is there's a draft bill which is pending, which has yet not been turned into an act of Parliament, and until and unless that doesn't happen, it sort of seems that as far as data privacy is concerned, we are in some sort of limbo. We are in some sort of a situation wherein things are not very clear as to how would data privacy be guaranteed as far as people whose Aadhar details have been collected in India are concerned. The court said Aadhar is necessary for a whole slew of government goods and services which are delivered by the government, maintained out of public funds, So it is necessary for subsidies, it is necessary for provident fund details, it is necessary for paying your income tax, it's necessary when you're accessing your wages under MGNREGA, it's necessary when you're accessing food and health and other benefits which are provided by the state. But when it comes to school admissions, when it comes to mobile telephony, when it comes to financial services, when it comes to bank details, well, the court takes a view and says that, well, in those cases Aadhar is not necessary, because in those cases it is something the court believes that sharing Aadhar details with those types of agencies might be an infringement of privacy. And especially given the fact that a whole range of benefits in the telecommunications and in the banking and finance sector in India are delivered by private firms, the court has a certain sort of view about it, and the court feels that there is a distinct threat as far as data which are used by these agencies is concerned. But nevertheless, what in all of this the court fails to take a look at is the fact that when it comes to last mile delivery of health, of medicine, of food, of a whole range of other things in India, though technically it is supposed to be done by the state out of public funds, last mile delivery most of the time is outsourced to private agencies. So, for example, the PDS shops in most places in India are not run by the government of India. They are run by people who are mandated to run them by the government of India, but they are nevertheless private agencies. They are private shopkeepers, they are private owners of their assets and their properties. And in that sort of situation, one just doesn't understand as to how should one square up all of this and try finding a way out of all of this, which sounds to be logical. B, nowhere as far as this judgment is concerned, as well as everything that went along with it, has at all any attention been paid to the fact as to what sort of benefits has the government of India drawn on account of the coming into existence of something like Aadhar. So, for example, Aadhar started off as a project of the UIDAI in 2009, which functioned as part of the Ministry of the Planning Commission. In 2010, the first Aadhar cards were rolled out. So we are like almost 8 to 10 years down the line. So we don't have, the government of India does claim that Aadhar has helped it balance out a lot of problems as far as the delivery of public goods and services are concerned. There has been a reduction in wastage and leakage and corruption and so on and so forth. Government sources do quote fanciful figures most of the time in the range of something like 90,000 crores, a trillion rupees. So it most of the time is the impression is given that, well, Aadhar helped the government of India conserve money to the tune of almost 1 trillion rupees on account of this whole plethora of things which has been done. Now, sadly enough, 1 trillion of what is just not mentioned. So we don't have any data, any verifiable, independently audited data in terms of what was the expenditure like in 2010 when the first Aadhar cards were rolled out, and what exactly is the change as far as these expenditures are concerned now in 2018. Anecdotal evidence across the country suggests that people are at a lot of hardship in terms of accessing what purportedly are their rights, is their own money, are their own wages. So they have worked for stuff and they're supposed to get wages, and they keep on running from pillar to post trying to get Aadhar validation, trying to get a biometric validation for things, and most of the time it just doesn't work. The court said that, well, that happens in just less than 1% of cases. In almost 99% of cases, validation does work. But try disaggregating these figures and one does come across a massive problem, in the sense that validation mostly fails in rural, tribal, remote India amongst people who are largely unlettered, illiterate, hardworking, hands are soiled. Validation works smoothly in urban centers, in metropolitan areas, wherein people are mostly working with telecom, with finance, with banking and stuff and stuff of that type. So you do have a problem in terms of validation is failing in one part of the country and validation is definitely successful in the other part of the country. And one just doesn't know as to how should one find a via media out of all of this, because the judgment just throws no light on that. When government sources say that ₹1 trillion have been saved, we are just never told as to what is that saving exactly made out of. How exactly is it that they have gone about saving? Normal cursory look at last mile delivery across the country would sort of convince people that there's a massive amount of corruption which is yet taking place as far as the grassroots level of delivery of delivery administration is concerned. So, wherein the government interfaces with society at the last mile, in the last stretches of the delivery mechanism and system, one does come across situations wherein corruption has not eased, corruption has not moderated, and nothing has given way. Yes, citizens do feel aggrieved and most of the time do take recourse to redressal mechanisms, but nevertheless do face a lot of trouble, and this trouble has just not vanished. So this is like the most hilarious thing under the sun that one can think of, it, if at all this is some sort of hilarity that one is supposed to think of. Aadhar started because of the fact that there is corruption in the system. Now, when they were talking about the system, they essentially meant the government delivery system. Aadhar goes about enrolling people with the idea that, well, if they are enrolled, the scale and the quantum and the incidence of this corruption would go down. Now, at the end of 2018, where almost 92% of 1.3 billion Indians do have an Aadhar card, what one realizes is, as far as last mile delivery of goods and services is concerned, corruption has just not given way. So one just doesn't know as to what does one achieve at the end of the day, wherein people who are supposed to be the receiver of these services almost as a right are almost penalized, are almost put to a whole lot of trouble. Whereas those who are the deliverers of these goods and services are, well, even today in their positions, wherein they are ruling the roost and wherein they absolutely nothing seems to have undergone a change. Well, was biometrics the right way of doing it? Because that is ultimately where most privacy concerns kick in. For a very simple reason, because most of them who are worried about the issue of privacy in connection with Aadhar are worried about the government generating and holding on to a massive database of biometrics. To begin with, biometrics started off, the earliest cases that one would come across were in 19th century India, wherein it started off as part of the colonial penalizing system, wherein they were using it for the administration of criminal law. So a crime has been committed, something has gone wrong and somebody has been apprehended for it, and they want to ensure that henceforth they would possibly not face that sort of trouble again. And so the most rudimentary biometrics were generated in the form of fingerprints. So fingerprinting is what started off with the Raj, which has been well studied by a whole range of historians, academicians of the Raj, as to how troublesome was fingerprinting and how troublesome was this whole process of generating, if at all one can say, the earliest and the most rudimentary biometric. But it was part of a penalizing system, it was part of administration of criminal law. And it's only after it succeeds reasonably in India, in the colonial situation, that this is adopted to be a mode of dealing with crimes back home in England, in the United Kingdom. So biometrics, as far as South Asia is concerned, as far as its originary moment is concerned, is connected with penalizing, is connected with crime and criminality. To use that as a way of delivering goods and services, which at least as far as the law is concerned, are supposed to be rights of the people who receive those goods and services, is quite a stretch of the imagination. So there's something inherently and fundamentally wrong about this sort of a system. Time and again, the authorities and as well as this judgment also talks about the fact that well, Aadhar is perfectly voluntary and nobody would be deprived of any access to goods or services on account of the fact that they don't have Aadhar number. Well, experience suggests otherwise. So if one takes the situation on the ground, one has known this for sure, that people have been rebuffed People have been denied their due share of goods and services precisely on account of the fact that they do not have Aadhar number, or they have not started the process of acquiring one. So in that sort of situation, what the law says possibly is not what the law means, because that is not what is getting implemented on the ground. And so one just doesn't know as to what should one do, for a simple reason, because if the final authority of the land, if the last court that one can approach has said it in so many in so many clear and certain terms, with no amount of uncertainty associated with it, that there is perfectly everything logical and constitutional about it, one just doesn't know as to where does one go further and beyond all of this. On the other hand, yes, when it comes to the accessing of financial services, when it comes to the accessing of banking services, telephone and telecom, they do have concerns of what is called as privacy. One just doesn't need to make this seem like the classes versus masses issue in terms of privacy for the classes and Aadhar for the masses. For a simple reason, because privacy, seriously speaking, the sort of privacy that has been talked about in India and the sort of privacy that is available to people in India is almost a figment of imagination of the law. We know for sure that we definitely don't have a much clearer demarcation between what is public and what is private as obtains in the developed countries of the world. As far as current everyday situations in India are concerned, the courts seem to be trying to bring that about in the Indian context, but it's possibly going to take a lot of time and possibly is never going to happen. So in that sort of situation, one just doesn't believe in this, that privacy should have had been the fulcrum, the point over which this entire argument should have had been situated. One believes that there was a definite reason to situate this around the question of rights, especially for people who are vulnerable, who are deprived, who are voiceless, and who most of the time are not in a position to make a case for themselves. And that's where one feels that most of the arguments which were made about this case in the Supreme Court simply seem to be arguments which just don't hold any truth on the ground. So you have people who are dying. You have these cases of girls in Jharkhand who passed away just last year in the month of September itself, on account of the fact that they were not able to access their due share of PDS food, for a simple reason, because they were turned away by saying that they don't have Aadhar, and in some cases their biometric validation doesn't work. So in that sort of situation, where people are already dying, where people are already deprived, where people are already in a difficult and troublesome situation, sounding it on the ground of privacy seems slightly different and slightly out of place. Having had said that, coming to another very important point that the judgment did point out, namely the fact that the Speaker of the Lok Sabha is perfectly entitled to take a call on whether a certain bill passed by the House is a money bill or not. The Aadhar Act, as was piloted to Parliament in 2016, was declared by the Speaker to be a money bill, which effectively meant that the two other bodies, the two other entities which are a part of lawmaking in India, namely the Rajya Sabha and the President of India, one feels that the time has possibly come in India where we need to have a very big debate about, do we really need the Rajya Sabha? If laws can be made by the Lok Sabha and there's perfectly no problem as far as the legality and their constitutionality is concerned, why are we sitting with the Rajya Sabha? What exactly is it that we are doing with the Rajya Sabha? And what exactly is the entire purpose of having 250 indirectly elected members if, when it comes to bills as critically important as this, they have, practically speaking, no say? And even if they do have a say, it just doesn't count. It seems that the last 4 years, and this judgment almost becomes a culmination of it, are a point at which we can definitely take a look at a constitutional system and say it's time to say goodbye to the Rajya Sabha. It's time to eliminate the House. It's time to add possibly those numbers, those 250 members, the number of those members to the Lok Sabha, and possibly make the Lok Sabha a 700 or 800 member house, which would be more reflective of political reality and would be more representative of people's opinions in India, rather than sit with a house which has absolutely no role when it comes to making laws. So all in all, On one hand, there is this entire problem of public and private that this bill has hinted at, that this judgment has hinted at, and has just not taken, it seems, not taken into consideration the fact that the practice of the state under liberalization for the last 25 years in India has been a practice of outsourcing significant aspects of the public delivery of goods and services in the name of economy, in the name of efficiency, in the name of more effective delivery of these services. And in that sort of situation, most of it is outsourced to private agencies. So when the court says that, well, private agencies, if they are accessing data, we need to have more safeguards. Those safeguards are lacking as of now. So in the absence of them, normally one should not share data with private agencies. But nevertheless, when it comes to the actual delivery of goods and services, it's private agencies that are playing the game all over the place. So in that sort of situation, this judgment gives you no clue or idea in terms of how should one exactly approach private agencies. On the other hand, is the problem that it's just 48% of taxpaying entities in India who have connected their PAN cards with their Aadhar cards. That's where the court expects more action, but it's as of now just 45%. Whereas when it comes to telephony, where it comes to telecom, the connections between Aadhar and the private firms are somewhere in the range of 87 to 90%. Most firms, as have been, especially in the telecom sector, have been instructed by TRAI, the Telecom Regulatory Authority of India, to come up with a way by which they can go about eliminating this data which they have gone about collecting across time over at least the last couple of years. Most telecom delivery firms in India went about perfecting a model of delivering their services whereby they were linking up their eKYC norms with Aadhar and thereby saving up on time, saving up on energy and saving up on everything, and thereby possibly even managing to reach out to customers, to a larger base of customers at a much lower price. And it seems that this judgment just pours cold water over all of that and demands for an offline way of doing KYC. And thereby for most firms this comes as a shocker in the sense that it seems that they'll have to almost rework their business plans and do something about it. But of course what's very interesting is the court says that these firms should not be repositories of Aadhar data, especially of biometric data, but they've already gone about collecting this data, and in the case of quite a number of firms, they have possibly, if anecdotal evidence is anything to go by, have already gone about shifting this data to other platforms. So in that sort of situation, how does one ensure that they comply with this judgment and they go about doing away with the data that they have stored, and their customers are assured about this, that well, nobody is toying and playing around with their data. So all in all, it seems that this judgment leaves behind a great many number of questions, then delivers answers to questions which were raised between 2010 to 2018. And it almost seems that there is something quite paradoxical about the situation, that 5 judges sit in the same courtroom, hear the same set of arguments, and yet come up with judgments which are stunningly at so big a variance to each other. Until and unless the next batch of cases doesn't go up to the court, which would definitely go up to the court in a very short period of time, to get a lot of clarity as far as the September judgment is concerned, one will have to live in this sort of situation of limbo. The government has ensured different stakeholders different things at one and the same time. So on one hand, it talks to the most deprived sections by saying that, well, they won't be deprived of anything, whereas on the other hand, it is ensuring private players in the telecom and in the banking sector that, well, they might think in terms of a legislation over the coming few days, which might in some way or the other moderate the impact of the court's judgment. Now in that sort of situation, it would be quite paradoxical that they go ahead and do something like this when the court has set it out in so clear terms that this is exactly what should not be done. The government is not prioritizing any data privacy law, any laws to safeguard data in India, whereas it is talking about the fact that it would go ahead and do something related to upturning at least portions of this judgment. So one judge doesn't know. It seems that we are in pretty interesting times. Thank you.
Press the bell icon on the YouTube app and never miss another update from the Unique Academy. Don't forget to like, comment and subscribe to our channel. Stay tuned.